So Gavin's asked a few questions in this group in relation to what I would say is a normal scenario to be in when you hold a visa that you don't want to hold anymore, but you're looking to apply for a partner visa. And what I was trying to express to Gavin is that there's certain things that are likely to happen for someone that's, let's say, on a student visa looking to apply for a partner visa. Now, firstly, the starting point is understanding that on a student visa, there are certain conditions, and this applies to any temporary visa. You could be on a student visa, you could be on a sponsored visa, you could be on a tourist visa. There's certain conditions that set expectations for you to keep holding that visa. You're obligated to do certain things to keep holding that visa. Specifically with student visas, is that you must keep your COE, meaning you must keep going to class and you must maintain a certain level of academic performance with the school that's issued your COE. The issue is that schools, they've supposedly very heavily regulated when it comes to what they're obligated to do. And basically they're obligated to notify the department if they're going to cancel a COE because a student either stops studying, doesn't maintain satisfactory academic performance, stops paying their school fees, those are the three most common reasons I would say, and they cancel the COE. If they do that, they have to notify the department. So basically they tell the department and they say, hey, this person's COE has been cancelled. Now, what happens, this is the department, okay, I'm trying to draw a building. What happens then is internally in the department, the wheels, the gears start turning in that they're going to action a cancellation on the student visa, because for you to keep holding the student visa, you must have the COE. If you don't have the COE, there's grounds to cancel the student visa under the Migration Act. I won't get technical in terms of sections and whatnot, not important that you know the section per se, but just know that that's the process. Now, what we find happens is that this process looks a bit like this. The government will send the visa holder like a warning, okay? Let's call it a warning, which we call a notice of intention to cancel. A notice of intention to cancel. Effectively giving them a time frame to respond by before they cancel the visa. From memory, 28 to 35 days. One of those time frames. Can't recall if it's 28 or 35, it's one of those two. However, that doesn't mean that you can give them reasons for them not to cancel the student visa. The only thing that would prevent them from cancelling the student visa is if you give them another COE that says, okay, well, I'm not with this school anymore, I'm now with this school, and then it's up to them whether or not they cancel the student visa, because the reasons that they had to cancel are no longer in place. You now have that COE again, so it's possible that they don't cancel it in that instance. But if you don't have another COE, which is, for people applying for partner visas, that's very unlikely, they're going to cancel the student visa. Okay, at some point, they're going to cancel it. Now, in the context of a partner visa, what's super important, the most important thing to know is that what you must prioritize, or likely want to be prioritizing, is submitting a partner visa prior to the cancellation of the student visa. So you want to be applying for the partner visa, that's a lot hard, before the cancellation, because in doing so, a few things happen. As soon as you apply for the partner visa, you get issued your bridging visa A. That's automatically issued to you. However, if after this has happened, they've cancelled your student visa, that's going to also cancel your COE. That's just how the law operates. When they cancel the substantive visa, it cancels any kind of bridging visas linked to it. However, you have already applied for a partner visa, meaning you're entitled to a different bridging visa, a bridging visa E, that keeps you in the country lawfully until you get the decision on the partner visa. Now that's all well and good, right? Okay, you've got a bridging visa E, means you can stay lawfully in the country. There's just a few things to understand regarding the bridging visa E though, is that there's no work rights generally. You have to apply for work rights, you have to show financial hardship, and there's no travel. In the sense that you can't leave the country and come back easily. You can leave on a bridging visa E, but you can't come back easily. and you need to be back here in order to get your onshore partner visa granted. So although it's possible to stay in the country lawfully whilst you're waiting for the partner visa, the realities of it though is that you could find yourself on a bridging visa E with no work rights, without the ability to go home and see your family whilst you're waiting for the partner visa, which can take 6-12 months, give or take, right? So there's a period there where you're kind of stuck waiting for an approval, possibly without the ability to work. So that's the general kind of sequencing of events when it comes to people on student visas wanting to get off because they're cancelling their COE, they don't want to pay their school fees anymore, they want to apply for a partner visa, but understand that yes, okay, that's fine as long as you apply for a partner visa before they cancel, but you're going to end up likely in that type of scenario. But the worst problem is if they actually cancel your student visa before you've been able to apply for your partner visa, because if that happens, then you're still going to end up on a bridging visa with no work rights, but the difference is that your partner visa is going to be subject to what's called Schedule III criteria, which really, in simple terms, means you need to be able to show compelling and compassionate circumstances to get this partner visa granted, which is not easy. And it's a very specific skill set, and I would say a high-risk application. We don't take Schedule III waiver cases on unless there's children of the relationship. In scenarios where there's no children, we refer those cases on to other lawyers and agents and deal with those types of cases exclusively. So if you're in the position where you're going to need a Schedule III waiver, firstly, Veazy is not suitable. We do not promote or recommend people that have Schedule III issues to be using Veazy. We do encourage them to engage legal professionals that know how to get Schedule III waivers in a variety of circumstances. But for our firm specifically, we only take on cases if there's children. Gavin, I'm just kind of reiterating everything I said to you in the group. Basically, the priority is to submit your application, which I believe you have. And really from here, it's a matter of waiting for the wheel of the government to turn and for you to get your notice of intention to cancel, the eventual cancellation. Then likely they might reach out to you and organise a time for you to organise your bridging visa E-appointment. That might be in person. I believe now it can be done online as well. And you organise the bridging visa E, that may be followed with the need to apply for work rights until the eventual partner visa is granted. And once it's granted, you're no longer on the bridging visa E, you're on your partner visa, and kind of everything's wiped clean. So I just wanted to reiterate what I was saying to you in the group, Gavin, and for the benefit of anybody else that might find themselves in a similar position, aka on a student visa, don't want to be on the student visa anymore, want to apply for a partner visa, understanding the kind of step-by-step implications to something like that.